Thank you very much. So first here, I'll turn on my camera and introduce myself. Good afternoon, folks, and thank you all to the host for having me on such a short notice. I know Brianna had been working on this, but she had to go elsewhere for work, so you're stuck with me. I'm her colleague, Brianna Wadley's colleague. I work mainly with the Tulsa and Fort Worth districts, core Fort Worth districts, and a little bit with the Galveston. So I used to work with the Albuquerque district many years ago. However, we transitioned, so it's been a while. There may be some of you that remember me, maybe not, but thank you all for being here. So I'll share my screen, or it's already being shared, but I'll exit the video. So today, just a quick presentation. You won't have to suffer through 56 slides. It's actually more like 16 on the updates on waters of the US in case you hadn't caught it. We've had several presentations over time, but might as well, go through it one more time. All right, so in today's presentation, we'll begin by covering some background on the waters of the US, including recent regulatory changes, litigation, and court cases. Then we'll review the framework of the 2023 rule, as amended by the conforming rule that EPA and the Department of the Army published in September 2023. As we'll cover in more detail later in this presentation, the 2023 rule and where it's applicable, which states. And then at the end, we'll cover some implementation tools and additional resources, not go through each of them, but what exactly they are and what we use and that type of information. A background on WOTUS. The Waters of the United States is a threshold term in the Clean Water Act. It establishes a geographic scope of the federal jurisdiction under the Act. So the Clean Water Act itself, the statute, does not define the waters of the United States, but rather EPA and the Department of the Army have defined waters of the US through regulations since the 1970s. And one more thing, I won't necessarily go verbatim for each of these points. It may take me longer, but I'll still talk through them. And at the end, if there are any questions, we can get into it. But I know that we're limited on time, and we definitely don't want to take away from our co-presenters. So this definition affects most programs that protect water quality under the Act, including water quality standards, impaired waters and total maximum daily loads, oil spill prevention, preparedness and response programs, state and tribal water quality certification programs, 401, and of course, the permitting program, 404, including for discharges of dredged and fill materials. So here in the screen, you could see all of these other sections in the Clean Water Act. As some of the background timeline, we've seen several changes across the history of it, and definitely in most recent times. The slide highlights the key regulatory changes in Supreme Court cases over the years that have affected the definition of the waters of the United States. And I've only been around 5 years with the EPA, and I've seen changes, but I think there was this maybe more impact to those individuals that have been around 30 or plus years. I think with that type of time span, it just becomes more impactful. So to set the stage, note that the longstanding regulations for defining waters of the US were established in 86 and 88 by the Corps and EPA. So these regs included a broad definition, which included traditional navigable waters, interstate waters, territorial seas, impoundments, tributaries, adjacent wetlands, and, quote, other waters which could affect interstate or foreign commerce. So US Supreme Court opinions came in 85, 2001 with Swank, 2006 with Rapanos, and 2023 with Sackett, which is the most recent one. But prior to the 2015 Clean Water Rule, the agents implemented the pre-2015 regulatory regime, which is a pre-2015 regulations that define waters of the U.S., WOTUS. They implemented consistent with relevant case law, a lot of lawyering and longstanding practice is informed by applicable guidance, training, and experience. The agencies ultimately revised their regulations in 2015 and 2019, and then again in 2020. In 2021, two district courts vacated the 2020 Navigable Waters Protection Rule. And at that point, the agencies returned to implementing the pre-2015 regime across the country. In January of 23, the rule then replaced the pre-2015 regulatory regime. And the agencies amended the January 2023 rule in September. As a result of ongoing litigation, as we know, the amended 2023 rule is not operative in certain states, and we'll discuss that in more detail here in a bit. Some recent events worth noting is in January 2023, or the January 2023 rule, which is called the Revised Definition of Waters of the United States, published in the Federal Register in January of said year. It took effect 60 days later on March 20th, 2023. In June of 2023, EPA and Army announced plans to issue a final rule to amend the January 2023 rule, consistent with the Sackett decision that was issued in May. And we issued that rule at the end of August. And the rule was published in the Federal Register on September 8th, 2023. That rule became effective immediately upon publication in the Federal Register. So here we see a map. Again, I'm not going to call it green, but greenish color is the 2023 rule is amended, and the light purple color is a pre-2015 regulatory regime consistent with Sackett. As a result of ongoing litigation on the January 2023 rule. So the agencies will implement the 2023 rule in 24 states, the District of Columbia, and the U.S. territories. In the other 26 states, the agencies are interpreting waters of the U.S. consistent with the pre-2015 regulatory regime and the Supreme Court's decision in Sackett until further notice. So you can see those areas shown there. It's actually what, lavender now that I think about it? Lavender. Additional information on the status of the January 2023 rule as amended and litigation are on EPA's webpage. So you can always visit that for a wealth of information. Some background on the very important Sackett decision. Again, this one's going to go in the history books. So let's discuss it a little bit. It was issued on May 25th, 2023. It's important to note that the January 2023 rule itself was not directly before the court in Sackett. However, the court did consider the jurisdictional standards that were set forth in that rule, including the permanent standard and the significant nexus standard. The Supreme Court concluded that the significant nexus standard was inconsistent with the court's interpretation of the act. And the court also concluded that the Rapano's plurality was correct, that the term waters, as used in the Clean Water Act, encompasses only relatively permanent, standing or continuously flowing bodies of water, including streams, oceans, rivers, and lakes. And for wetlands, the court also agreed with a plurality that to be jurisdictional, wetlands must have a continuous surface connection to water bodies that are waters of the United States in themselves, in their own right, so that there is no clear demarcation between waters and wetlands. Now, based on that court's decision, EPA and Army determined that the regulatory text of the January 2023 rule needed to be amended. So there was work to be done after that decision. Some additional background in this conforming rule. So that conforming rule was published in the Federal Register in September. And in that rule, the agencies determined that there was good cause under the Administrative Procedure Act to issue a final rule without prior public notice and opportunity for public comment because certain provisions of the January 2023 rule were invalid under the Supreme Court's interpretation of the Clean Water Act in Sackett. And the conforming rule made targeted changes to the January 2023 rule jurisdictional categories, including removing interstate wetlands from the interstate waters provision, deleting the significant nexus standard from multiple provisions, and deleting streams and wetlands from the paragraph A5 additional waters provision, so that the category it's limited to assessing lakes and ponds under A5. The conforming rule also made targeted changes to the January 2023 rule definitions, including deleting the definition of significantly affect and revising the definition of, quote, adjacent to mean having a continuous surface connection. The conforming rule did not, however, change any of the January 2023 rule exclusions, which we'll talk about here next. Excuse me, in a future slide. So with that background, let's review the amended 2023 rule, which New Mexico, it's implemented in New Mexico. Normally I work with pre-2015 regulatory regimes, and Brianna gets to work this one. So this slide lists the categories of paragraph A jurisdictional waters, including in the 2023 rule, which have all been retained. The first category is traditional navigable waters, which are waters which are currently used or were used in the past, or may be susceptible to use in interstate or foreign commerce, including all waters which are subject to the ebb and flow of the tide. So that's right out of the reg. There wasn't enough space to put everything here, so you'll just have to listen to me. Examples include the Mississippi River, Erie Canal, and Great Lakes, these huge water bodies. And the second category, the territorial seas, examples of that include parts of the Atlantic Ocean, Pacific Ocean, the Gulf Coast. Third category is the interstate waters, and examples of these include Lake Tahoe, parts of the Columbia River, and portions of the Savannah River, to name a few. And then we have A2, which are impoundments, waters of the US. After that, it's tributaries of traditional navigable waters, the territorial seas, interstate waters, and paragraph A2 impoundments. So to be jurisdictional, tributaries must meet the relatively permanent standard. And the 2023 rule preamble explains that the relatively permanent waters include tributaries that have flowing or standing water year round, or continuously during certain times of the year. Relatively permanent waters don't include tributaries with flowing or standing waters for only a short duration in direct response to precipitation. After tributaries, the next category covers adjacent wetlands, which are A4 in this case. Under the amended 2023 rule, adjacent means having a continuous surface connection. So wetlands are jurisdictional under this category when they're adjacent to a traditional navigable water, the territorial seas, an interstate water, or a relatively permanent tributary, or a jurisdictional impoundment. So everything is situational dependent as far as when we won't talk about it, but jurisdictional determinations are conducted. Now, waters assessed under paragraph A5 meet the relatively permanent standard if they are relatively permanent, standing or continuously flowing bodies of water with a continuous surface connection to a traditional navigable water, the territorial seas and interstate water, or a relatively permanent tributary. Now, as far as the 2023 rule exclusions, under paragraph B, The conforming rule does not change any of the paragraph B exclusions included in the January 2023 rule. The first two um, are from the pre-2015 regulations, including waste treatment systems and prior converted cropland, but they've been modified in the agency's 2023 regulations. The remaining six exclusions are the generally non-jurisdictional features under the pre-2015 regime, which were added to the January 2023 regs as exclusions. So these exclusions are specific to the definition of waters of the US. However, I do want to take the opportunity and note that the definition of waters of the US doesn't affect agricultural activity-based exemptions under the Clean Water Act. Most routine ongoing farming activities do not require Clean Water Act Section 404 permits. The statute itself identifies certain normal farming activities that don't require dredge and fill permits, and the definition of waters of the US doesn't change that. The permitting exemption includes many common activities like plowing, seeding, minor drainage, as well as activities like the construction and maintenance of irrigation ditches and maintenance of drainage ditches. In addition, the definition does not affect the existing statutory or regulatory exemptions or exclusions from Section 402 NPDES permitting requirements, such as for agricultural stormwater discharges and return flows from irrigated agriculture, or the status of water transfers. So this, I think the previous three slides were the meat and potatoes as far as the, the framework. And as I promised, it wasn't the 56 slides, but I think as part of our work here in the regulatory business, and many of y'all would know, is there have to be tools and resources. So some of these tools, for example, are listed below and then the following slide. It's not all inclusive, and the agencies will leverage multiple tools to make best informed determinations on what is WOTUS and what is not WOTUS. So this slide and the next slide review tools available. Direct observations and regional field observations are of course important, very important. And another tool that I also want to highlight is stream flow duration assessment methods, which provide regionalized methods based on field indicators of stream flow duration. We have mapping data sets, and models are also helpful for assessing stream flow duration. For example, the USGS National Hydrography data set and regional regression analyses and other hydrologic models. So it's a long list, but I think the most important aspect is they can all be very useful. And it helps make a very well-informed decision. Some additional stuff here. A couple examples include LIDAR, state and tribal data and maps, the NRCS soil maps, of course, and coastal areas, NOAA national snow analyses maps, or beyond that, as well as national scale map viewers like EPA's Water GeoViewer and NEPA Assist. So plenty of tools out there to conduct analyses, and just some additional stuff. No need to go over every single thing, but I think you guys get the point. I hope I drilled it home. Now, as far as additional information or questions, I would encourage you to visit our website for that. We've packed it with all sorts of information related to WOTUS. We've also in the past posted public webinars just to inform the public, the agencies, tribes, states. We've also, posted additional information that you may consider very useful in your day-to-day work. But I hope I made it under the 20 minutes. I tried my best. Again, this was a shortened version, I think, just to give everybody a quick overview of WOTUS under the 2023 regime. What happens in the future, I don't know. Nobody knows, but we do live in interesting times. Again, I got here 5 years ago, and it wasn't just WOTUS that was undergoing transformation. I also deal with Clean Water Act Section 401 water quality certifications. So there's been plenty of changes there, and other regulatory programs. And the most important thing is, I think the best thing that we can do is adapt. Some things are out of our hands, but apply them and implement them as best as possible according to our guidance. But yes, and thank you very much for attending and listening. I hope I didn't put some of you guys to sleep. Anyway, that's all I got as far as the presentation. Thank you very much.
My name is Shelley Lemon, and I am the Surface Water Quality Bureau Chief for the New Mexico Environment Department. And I'm here today to give you an update on our surface water quality discharge permitting program development. And I'm glad Daniel went first, because I do have some slides about the whole history and why we're pursuing a state permitting program at this time, but I can move past those slides and actually be on time with my presentation. So that's a good thing. So starting off, on your screen is the famous picture of the Cuyahoga River on fire. The Cuyahoga River is in Ohio, and it was once considered one of the most polluted rivers in the United States. And it caught fire a total of 13 times, dating back to 1868. And it caught fire once again in 1969, and many people believe that was the impetus for enacting the Clean Water Act and the passage of the Clean Water Act in 1972. On the right-hand side of the slide is the Cuyahoga River today. So it just demonstrates the effect that the Clean Water Act has had on our waters and rivers throughout the United States. So I'm going to give a little bit of background about the Federal Clean Water Act. The overarching objective of the Clean Water Act is to prevent, reduce, and eliminate pollution, to restore the physical, chemical, and biological integrity of our nation's waters. And there are two goals to achieve this objective. The first is to improve water quality so that all waters are fishable and swimmable. And the second is to eliminate the discharge of pollutants to waters of the United States by 1985. Don't think we hit that goal yet, but that does not mean we haven't made progress. And water quality has improved under the authority of the Clean Water Act, which has had direct benefits. Oh, I didn't even do that. Sorry. I'm having a hard time here. Okay. Has had direct benefits on drinking water, public health, recreation, wildlife, and local economies. And then when the Clean Water Act enacted, or when the Congress enacted the Clean Water Act, they wanted federal governments and state governments to share that responsibility in what's known as federal cooperatism. Federal cooperatism? Am I saying that right? And it's a shared responsibility. And so with the change in definition of waters of the US recently, that's pushing more of the responsibility onto the states to protect waters in this state. So there are federal protections here in New Mexico, as Daniel said in the first slide. Under the Clean Water Act, it is illegal to discharge a pollutant through a point source into a water of the US, or we shorten that to WOTUS, without a permit. And waters of the US refers to the surface waters that are under federal Clean Water Act jurisdiction. Obviously, that scope has changed over time, and that whole history that was provided in the previous presentation tells you that it's not an easy thing to do to define what is under federal jurisdiction. So it's up to the states to help define that line. This is the Supreme Court's decision. The key terms here are that right now in New Mexico, surface waters are protected under the Clean Water Act if they are relatively permanent, or they have a continuous surface connection to a jurisdictional water. You look outside, there are not a lot of waters that are relatively permanent or have continuous surface connections. So it's problematic in New Mexico. Many of New Mexico's surface waters are likely not protected under the Federal Clean Water Act anymore as a result of the SACA decision. Some of the waters that I've listed here are likely out, including ephemeral waters, wetlands without a continuous surface connection, previous adjacent wetlands, isolated wetlands or ponds and lakes, and some interrupted streams. We have streams that are perennial, but they go underground and then they pop back up again. So if there's not a continuous surface connection or they're not flowing continuously, and also intermittent waters. So just to put this in perspective, a little more than 3% of New Mexico's surface waters are perennial or relatively permanent, and roughly 97% of our surface waters are non-perennial and no longer protected under the Clean Water Act, which means that if a discharger is discharging pollutants into a stream in New Mexico, it's a high likelihood that they do not require a federal discharge permit, either through the NPDES program, the NPDES program, or the 404 dredge and fill program. That is highly problematic because without a permit or without a state-led permitting program, it's going to be very difficult for New Mexico to protect surface waters of the state from contamination and degradation. Oh, how did I click out of this?
Oh.
I think the wrong button. So just to give you a general framework that the Surface Water Quality Bureau uses to identify and restore to impaired waters, I've provided this diagram. And so essentially you have to develop water quality standards first, and we have a Water Quality Control Commission that adopts water quality standards. My bureau will go out and monitor. We collect biological, physical, and chemical data in our surface waters. And we take that data and we assess it against the standards to see if it is meeting those standards. If the water does not meet the standards, then we list it on the Clean Water Act Section 303D list of impaired waters. And from there, that list is used to develop total maximum daily load documents or watershed-based planning documents. And those planning documents are then used to implement protections and projects on the ground, either through discharge permits and setting effluent limitations, or through on-the-ground restoration projects through our 319 program and our river stewardship program. We also have in our state, state water quality protections under the New Mexico Water Quality Act. And the New Mexico Water Quality Act was adopted in 1967, and it protects the water quality at the state level. So the Water Quality Act provides authority for water quality management in New Mexico, and it also created the Water Quality Control Commission, which is the state water pollution control agency for New Mexico for all purposes of the Clean Water Act. So what does that mean? Under the Clean Water Act, a state water pollution control agency means the state agency designated by the governor as having the responsibility for enforcing state laws to reduce relating to the abatement of pollution. So I've highlighted on, yeah, oh my gosh, that is not it. That's it. Okay. Some of the responsibilities of the commission include adopting water quality standards, adopting, promulgating and publishing regulations to prevent or abate pollution, and specifying regulations to prevent water pollution or to monitor water quality, and also adopting regulations to be administered by the Environment Department for surface water discharges. So where are we right now? Right now in our state, we do not have authority to issue Clean Water Act discharge permits or any surface water discharge permit. In New Mexico, the NIPD's permit program is administered by EPA in Region 6, and the Clean Water Act dredge and fill permit program is administered by the Army Corps of Engineers. The New Mexico Water Quality Act has authorized the state to require permits for the discharge of pollutants into waters, but currently the state of New Mexico only has a permitting program for groundwater. It doesn't have a permitting program for surface waters. But under the regulations adopted under the Clean Water Act and New Mexico Water Quality Act, New Mexico does certify federal permits under the Clean Water Act Section 401. And those certifications are to ensure that water quality meets our state water quality standards, as well as our water quality management plan and our anti-degradation provision. So some other where are we now? These pollutants are continuing concerns and also new concerns. Just as the program grows and develops, there's always more that comes along the pipeline that we have to consider and come up with solutions. And so you'll see on the bulleted list, I have chemical, physical, and biological contaminants that we look at in the Surface Water Quality Bureau to evaluate the water quality of our surface waters. That goes back to that Clean Water Act goal to restore the biological, chemical, and physical integrity of our nation's waters. We also have emerging contaminants that we're starting to look at and monitor, like PFAS, personal care products, and pharmaceuticals. And stormwater is always a big issue, but it's becoming more of an issue with climate change because the climate patterns are different. And so you get higher intensity storms, you get wildfires that when it rains after a wildfire carries a bunch of stormwater contaminants into the streams. And so the concerns listed up here pose significant threats to our water quality and to our aquatic ecosystems, but there are actions that we can take to help improve the situation, like fixing or replacing aging infrastructure, building green or nature-based stormwater infrastructure, and finally, implementing a state permitting program to control the discharge of pollutants. So the scope of our proposed permitting program, I've already mentioned that New Mexico relies on the Federal Clean Water Act permits to control the discharge of pollutants into our surface waters. But what we're proposing, what the Environment Department is proposing to do is twofold. And basically, we're looking at seeking delegation from EPA for the NPDES program, NIPD's program, for point source discharges. So we would take over that program from EPA in New Mexico. We're not seeking authorization of the 404 dredge and fill program from the Corps. We're letting the Corps continue to administer that program. And then we're also designing a program for surface waters of the state under the Water Quality Act, which will be for both point source discharges into non-WOTUS waters, or waters that are not jurisdictional under the Clean Water Act, and also a program for dredge and fill discharges into surface waters of the state, which are not waters of the US covered under the Clean Water Act. So I'm going to cover a couple of slides just to make sure we're all on the same page when I'm talking about different types of discharges. So for point source discharges, EPA defines a point source discharge as any identifiable source of pollution. from which pollutants are discharged. So like a pipe, that picture shows a pipe going out, stormwater conveyances, you know, a ditch, a ship or a factory that is discharging into a water body. That's a point source discharge. And under the Clean Water Act, the NIPDES program regulates these types of discharges into surface waters. For dredged and fill discharges, dredged material is material that is excavated or dredged from waters of the United States or surface waters in general. And fill material is defined as material that is placed in surface waters where the material has the effect of replacing any portion of a water with dry land or changing the bottom elevation of any portion of the water. And like I said previously, the Army Corps of Engineers will continue to regulate the discharges of dredged and fill materials to waters of the US under the authority of the Clean Water Act. But NMED is developing a state program to regulate discharges of dredged and fill materials to surface waters of the state that are not covered under the Clean Water Act. So what the steps to program approval are outlined on this slide, and there are several different steps we need to take in order to gain program approval and actually start implementing a discharge permitting program. So on the right-hand side of the slide, we're talking about the state program to surface waters of the state that are not protected under the Clean Water Act. That would include both point sources and dredge and fill discharges. And the steps in this process are engaging stakeholders. We will need to draft rules, conduct a rulemaking hearing, and also once that rule is adopted, we would have to start implementing that rule. For NPDES primacy, again, it's very similar to the state program, except we need to actually submit an application to EPA to demonstrate that we have the capacity, the funding, and the resources to administer the NIPDES program successfully here in New Mexico. So we have to build the program before we can take over the program. So speaking to that stakeholder involvement piece, the Environment Department convened a surface water advisory panel composed of a variety of different stakeholders across New Mexico, with the basic premise being that the discharge of pollutants to surface waters is not a right. The SWAP met 6 times from August 19th through October 25th. So we just completed this stakeholder process, and the purpose was for those stakeholders to help NMED develop a state permitting program by providing technical information, practical considerations, and policy perspectives relevant to adopting and implementing a state permitting program, and also informing the department's development of legislation and rules for consideration by the Water Quality Control Commission. NMED plans to post a final SWAP report on our website that describes the SWAP process and topics discussed, the issues that were raised, and also any clarifications that are needed. And NMED will post additional information and updates to our website that is located or identified on this slide. Well, okay. Why am I having so many different? Okay, so another thing that we will need is legislation. So the department is proposing legislation for this upcoming legislative session in January. We have 2 things that we're going to be introducing. One is the NMPDES, it just rolls off the tongue. NMPDES Delegation Act, NMPDES, I like to say. And basically that is that will give the state the needed authorities to obtain and retain authorization to implement and enforce the federal NIFTYS program here in New Mexico. And we are also proposing to make a couple of amendments to the New Mexico Water Quality Act, basically to help with implementing the state water quality permitting program. We want to authorize the use of general permits in a state permitting program. We want to update and modernize the public notification requirements, allow for the requirement to mitigate for unavoidable impacts to either surface water quality or water resources, and incorporate an anti-degradation provision to protect high quality waters in New Mexico, and then also amend oversight responsibility for discharges to surface water currently under the Oil Conservation Commission jurisdiction. So a lot going on. Another area that will need some attention as we develop and implement a state permitting program is mapping. Very high quality surface water maps are helpful to not only the department, but also to the regulated community, because they assist with jurisdictional questions. They help to determine a discharge impacts to a surface water or watershed, and they assist the regulated community in determining if they need a permit or not. NMED is partnering with other state agencies and the USGS to develop case studies for the USGS 3D HP mapping that they are undergoing right now. We're looking to test it out on priority watersheds and then expand that out as funding becomes available. But 3D HP is not the only mapping tool, so we're also looking at developing a map for surface waters to help with the state permitting program and the questions that people have. So speaking of all of that, our estimated program costs and revenue options, you know, it depends on what's approved in the 2025 legislative session and also what's subsequently adopted as a rule through the Water Quality Control Commission's rulemaking hearing. So, and then how we implement those rules will depend on how many FTE or full-time equivalents we will need to implement the program. And FTEs include permitting, compliance, enforcement, data management, administrative management. So it can include legal assistance and HR, and also needing somebody to help with fees, so that administrative piece. So it's looking, you know, based on some estimates, we will need 40 to 60 additional FTE. Right now we have about 10 to 12 FTE. It's a range because our personnel aren't dedicated 100% solely to either the NIFTYS program or the 404 dredged and fill program. We have a variety of different responsibilities and duties. So it's an estimate and a range. And that workload will require an additional $7 to $8 million per year. That's for full implementation of the combined program, so both NIFTYS and a state program. And current costs are approximately for our 401 certification and compliance inspection program is around $900,000 for the staff that we have. We have a couple different funding options to pay for the program. One is 100% fee-based, which the permittees would pay 100% of the program costs. Another option is to have the legislature subsidize the program, 100% legislative appropriations, which is both options are a little bit scary. So maybe the mixed, the most desirable way to fund the program is a combination of fees and general funds. Or we could look at something more creative and look at an investment fund for New Mexico. We passed the Land of Enchantment Legacy Fund, which is supporting conservation efforts, and our river stewardship program in the Surface Water Quality Bureau. Maybe there's something that could come up with an investment fund like that as well. Our timeline is posted here. So we just completed the Surface Water Advisory Panel process. We're going to the legislature in January, and we will, depending on the outcome of that, what authorities we have, we will be drafting rules. And we should have draft rules for public comment in the summer of 2025. So next, couple months, which is crazy. And then we would request a rulemaking before the Water Quality Control Commission in the fall of 2025. So when we issue the rules, we put it out for public comment, we respond to public comment, and then we go to the commission to request a hearing. We anticipate that the commission having a hearing sometime in spring of 2026 and actually deciding on that sometime in calendar year 2026. We have the hearing, and then there's a whole bunch of post-hearing actions that need to happen, and they do deliberations, and then they make their final determination. So it may be a process, but sometime in calendar year 2026, which means we would have our initial rollout of the state program in 2027, 2028 timeframe. And once the rules are adopted, that's when we can apply to EPA for the federal NIMDs program. So we would also be applying for the federal program authorization sometime in 2027 or 2028. And if you want to learn more, or if you have comments, or you have questions, we have an email address that you can send us to, send your questions and comments to. Our Surface Water Quality Bureau website for the state permitting program is up there, and also for the advisory panel. So there's information on the web, and that is the end of my presentation. So I don't know where I'm at time.
What impact, if any, these proposed rules or regs have on advanced facilities or irrigated lands, acequias and ditches and so forth? What effect will these have?
The permitting program that, as I believe Daniel touched on, agriculture, traditional agriculture is exempt.
You will exempt
And
federal.
we will exempt for federal, and we want to carry over similar exemptions for the state program. Do we want to have questions now?
It's up to you if you're done. Yeah.
Doesn't matter. Was there a question?
Right now, before you get adopted, what happens if there's a discharge to an federal or a federal beach? Is it a groundwater discharge permit?
It depends on if it's a planned discharge or an accidental discharge. We can enforce both surface water and groundwater depending on the water body and also the type of discharge. So we're being reactive instead of proactive. If it's to an ephemeral stream and it's like a continuous discharge, it will depend on where that water body is in relation to a jurisdictional waters of the US. Because if it creates a surface connection, I believe that EPA would regulate that. I mean, City of Santa Fe has that situation. And the thing is, it needs to make it to a jurisdictional water. Like, it's gotta be, so it depends. Yes, it could be a groundwater discharge permit. It could be a surface water discharge permit through EPA right now, or it could be enforcement.
wondering, are there any other states that are going through a similar process that you guys are talking to or have learned lessons learned from others that could be?
Idaho recently went through NIPD's delegation, so we're talking with Idaho. Alaska went through it recently, we're talking with Alaska. But really for the NIPD's program, most states have had it for decades, so there's only 3 states that do not have authorization for that federal program: New Hampshire, Massachusetts, and New Mexico. So we are talking to other states and asking, and we're talking with EPA. Obviously, I didn't put it in my presentation, but we are in many communications with EPA because they also have to be okay with our legislation and our regulations in order to actually approve the program. So lots of communications right now. Yeah, Dan.
So because of SAC, EPA's been banning it for our stack. So are we trying to match what they've been doing or expand on?
It would be an expansion. Well, it's so because the definition of waters of the US and what's jurisdictional has kind of shrunk. EPA and the Corps used to regulate these waters, and now they're regulating these waters. So we're trying to fill that gap with a state program and also the federal NIPD's program. So we'll take over the federal program for NPDES and then develop a state program for the waters that were lost with the recent changes. Thank you.
Yeah, if the waters that were lost, no longer regulated by the feds, then how do you answer my question, is the state gonna try to get in there and regulate agricultural activities in that area, that gray area?
No, we will have similar exclusions and exemptions to the federal program. And that was part of the topics that we talked about with our stakeholder groups, and we did have the New Mexico Acequia Association representation on there. And we have some agriculture representation on there, so we're not looking to regulate agriculture or return flows. What we want to make sure is the water that you're receiving and getting for your agriculture is clean, so you can use it for that irrigation, right?
I wasn't right in Idaho, one of the first ones, went through the whole privacy thing. But one thing that did get sticky with irrigation is there's irrigation ditches that end up replacing past waters. And we would regulate like a wastewater treatment plant that's discharged into a ditch. We wouldn't, we would trace that ditch down to a water US and regulate it that way. We wouldn't actually regulate the actual ditch water. Just what goes into the ditch.
Right. Through that point source.
Yes.
Right. So, again, going back to that definition of point source where there's an actual discharge of pollutants. This topic did come up of like where it's regulated, if it's coming in, and we have organizations that deliver water. Are they responsible for the pollutants that they're delivering because it's through a pipe, you know, but they're just getting, that's not the intent. I agree. It's sticky.
But let me carry that one further. I understand you would regulate the discharger into a ditch. Does the discharger definition go to the pharmacy?
Does the, excuse me, I didn't catch that.
I think the point was made that you would regulate a potential polluter through the ditch, i.e. a ditch start from a plant. Some kind of My question is, do you classify the farmer in that category if he is using some kind of chemical on his farm?
That, I mean, again, it goes back to that definition of point source. And, you know, we're looking at regulating point source dischargers and dredge and fill dischargers.
But the question was, would you consider the farmer a point source discharger?
No.
Well, I'm just following up.
No, because there will be exemptions that are identified in either the rule or legislation. I'm not sure. I don't know where it's at right now off the top of my head, but things that are excluded from regulation, right? So those things will be identified as being excluded.
I'm Colleen Cunningham. I'm with the New Mexico Interstate Stream Commission. I'm the environmental coordinator, and I was asked to sort of broadly speak on what all these changes mean to both the Interstate Stream Commission and the Office of the State Engineer. So I'm honored to represent both agencies today. We are separate agencies, in case anyone had any questions about that. I would say, like most New Mexicans who are up on water issues, we were concerned about the Sackett ruling and what that would mean for waters in New Mexico. And we are very supportive of NMED and the program that they're putting out. Waters of the state doesn't quite roll off the tongue yet, but we'll all get used to it. But we are super supportive of this. But before I go into our reasoning behind that, I wanted to talk a little bit about what the two agencies do, because I find that people are generally confused about that. Who knows, who's heard of the Interstate Stream Commission? People who work for state government. So we consider ourselves a sister agency to the Office of the State Engineer. And so I'll talk first a little bit about the Office of the State Engineer. So both of our agencies really deal with water quantity as opposed to quantity. The state engineer has authority over the supervision, measurement, appropriation, and distribution of surface and groundwater in New Mexico. OSC issues permits for surface and groundwater diversions. That's an important difference between the two agencies. So the ISC doesn't issue permits. What we deal with is investigating, protecting, conserving, and developing New Mexico's waters, both interstate and intrastate. We have the authority to negotiate with other states over controversies for interstate streams. And we also do a lot of planning. We have a whole planning division, along with our bureaus that are devoted to the main river basins in the state. But we don't issue any permits. What we do primarily is work on interstate compact plans. So we support the NMED in developing the GAP program and taking over NPDES delegation. First of all, we really think this will reduce a lot of uncertainty for our water users. Everyone is a little bit unsure where the line is on federal waters these days. We also support having more local control and local solutions for New Mexico specific problems. New Mexico is not like Florida or Ohio, or other states. We have very specific issues here. We also think that it's a potential for things to be a lot easier for our water users. They'll have local people to connect with. The process should be easier than dealing with the EPA or the Corps. I was happy to represent both agencies on the Surface Water Advisory Panel that Shelley talked about. We thought that process was a great opportunity for a whole diverse group of stakeholders to get together, talk very candidly about concerns and issues, and throw out possible solutions. We really thought that that was quite helpful, and we're hoping that that helps NMED build out a process that gets a lot of buy-in from the water users of the state. We also think this is another avenue for greater coordination among state natural resource agencies. I think there's a long history of pretty good coordination already between NMED and OSC and ISC. We have a 1999 letter of understanding, which outlines how the two agencies will interact. But again, another avenue for all state agencies to really come together that deal with water. And I think this is especially important given climate change hydrology, which has introduced a lot of variability in timing, amount, types of precipitation our state receives. And so that makes our water management issues all the more difficult. Let's see. So I covered the fact that neither of the agencies deal with water quality. So you're probably wondering, why do we care about a water quality permitting program? Our purview is definitely more utilization, water rights, water movement. We are involved in a couple of water quality programs, primarily related to salinity, but we don't have the authority over water quality. That is squarely an NMED area. But we do have an interest in discharge permits. Changes in points of discharge could affect compact compliance or timing of water deliveries to meet compact compliance. So those are the types of permits that we would be interested in looking at so we can make those decisions. If a discharger previously is discharging immediately upstream of a gauge that we look at when we figure out our compact delivery compliance, and they change their point of discharge somewhere else quite far away, that could change the calculation. So those are things we're interested in. We're also interested in projects that hold water or delay water. So stormwater retention projects delay the movement of water, totally needed. We should have more of them in New Mexico to manage our stormwater, but there are certain rules and guidelines that go with this. Most people in water know about the 96-hour rule for holding stormwater. In certain cases, there can be variances for that. There's not a whole lot of that. But things like beaver dam analogs that can be very useful in habitat creation or restoration, and also for groundwater infiltration, can also have water rights impacts. So we want to look at those, figure out if there's a depletion or a right that's impacted, if the applicant actually has a water right to do this. Same thing with other types of habitat restoration or creation projects. One thing that I encounter a lot is that people don't quite understand that if you create a wetland, this could create actually a depletion of surface water because that wetland area takes water from the main stem holds it, and there's evaporative loss and sometimes groundwater infiltration. Neither of which is a bad thing, but we want to make sure that no downstream users are impaired, there are no water rights impairments, and that the person with the application has a water right to cover it. So these are areas where, you know, we would like to coordinate really closely with NMED on. Another thing that I was thinking about is that we have quite a few programs where we provide project funding. And that all of these projects would have to comply with the new state program. I don't think that's going to be a problem, but the folks that we provide money to will have to work this into their planning process. And so just a few of the projects that we provide money for are Indian water rights settlements. And so this one took me a little bit to get a handle on, because you would think from the name that it is actually water projects for tribes. But in fact, this is money we received from the federal government to allow non-Indian water users to utilize water. So those projects would need to comply. Our Arizona Water Settlements Act projects. So that's a very large pot of money we have that we got through the Arizona Water Settlements Act. It's targeted for 4 Southwest counties in New Mexico for water utilization and conservation. Those projects would need to comply. That program is going to start its pilot funding cycle probably after the first of the year. So we're working with Water Trust Board on that. Another program we have is, I just generally labeled it Rio Grande projects, because we have a lot of things going on in Middle Rio Grande and also Lower Rio Grande related to water conservation and habitat improvement. And this program, funding program, is really getting built out right now. We also have an Isikia program for funding, but as Shelley said, our assumption is that because those are agricultural projects, they'll be exempted. So we're not as concerned about that. Other projects that are not necessarily funded by the OSC, but that the OSC reviews and may be subject to the discharge permitting are Water Project Fund projects, Colonias Infrastructure Fund projects, and capital outlay projects. So I think it's really just going to be a matter of educating applicants on what their compliance responsibilities are. But as part of the swap process, I think NMED is working. They outlined that they're working on a public outreach process. So I think from a water user standpoint, we should be in pretty good shape by the time the program's rolled out, as far as getting people familiar with it and what their responsibilities may be. So my presentation is pretty short and sweet and not nearly as technical. I'm happy to answer any questions you guys have now, or feel free to email me if you have any questions related to what the ISC does or what the OSC does. And if I can't answer it, I'll point you in the direction of someone who can. Thank you.